we do not have an agreed plan on how to go forward. My argument is this. This was heard 3 weeks ago with Judge Warning, with essentially the exact same evidence. The difference between today and Judge Warning is essentially, even per the mother's declaration, is that at the first exchange of the 4-year-old, the 4-year-old had a meltdown and cried. That is the big change. That is not the basis of an ex parte restraining order. Judge Warning heard this, had the same brick or nearly the same brick of information, but the only change, the only new thing that has happened is that the 4-year-old doing an exchange at night in front of a police station with officers present, mother doing the exchange. So we have not a neutral party doing the exchange, so not ideal. We have a 4-year-old, a preschooler, having a meltdown. Not too shocking. My client wants to have visitation. He does not want this to just simply be kicked down the road and not having visitation. Mother agrees that visitation happened for the older 2 children. There's 4 children at issue. The older 2 children continued to have visitation with my client this last weekend. The court ordered every weekend to my client from Friday to Monday morning drop off. So the other 2 children with my client with no issue. The 4-year-old cried, so we got an ex parte restraining order Friday at, essentially my client responded without ever having seen the motion. So we just were told it was coming over and we made a good faith effort to put a declaration together, but here we are. So my client doesn't believe this is valid. It's not reasonable. This is not how we do business. They were aware on Friday that this incident happened. We're going to then waiting until the following Friday at essentially 1 o'clock to then provide the motion. This isn't reasonable. The court then reasonably gets a brick of paper, not knowing it's the same brick Judge Warning got.
Bear with me. May have made this too big.
And then says, oh, well, this, I see a brick of paper, must be substantial. I'll sign the ex parte restraining order, making it so that my client doesn't have access to the 2 youngest children. My client thinks it's imperative that he have visits with these children. The guardian ad litem is doing an investigation. Hard to say what those children are like in my client's home if he doesn't have them in his home. And there's really no statement that the 2-year-old has any issues at all. So as to my client, he does not want to just kick the can down the road and say, oh, well, we'll just kick it and go additional weeks. Judge Warning made this order essentially the first week of March. We went multiple weeks without the order being executed. So essentially mom then delayed the visitation. We had modifications made in the DVPO order. We had modifications made in the criminal case. So all of that was aligned. The very first weekend this exchange was to happen. Now we have this reason and a very late breaking restraining order that doesn't make a lot of sense. I'll note for the court, mother's very first exhibit that she attaches to her declaration is, oh, look, by the way, he's got an old 2008 felony. She provides that judgment and sentence, but doesn't provide that it was vacated 2 years later. So these are the types of pieces of evidence, I think, that are very misleading. Is when you say, oh, there's a big judgment and sentence. It's almost 20 years old, and it's been vacated. So again, in this case, I'm asking the court to allow visitation to continue as it was intended. After that, I don't disagree then setting it out, allowing my client to have the visits that the court intended and to allow the guardian ad litem to investigate as intended with all of the children in both homes so that it can be investigated in both homes.
And Your Honor, if I may.
Let me ask a question. The order that we're working under prior to the current restraining order, that's the order that was entered 3/15. Looks like Judge Evans signed it, but I believe that was Judge Warning's order. Is that correct?
Yes, that's correct.
Okay, I just want to make sure I'm looking at the right.
Temporary order, and then it's not a parenting plan, it's a temporary order that has the details. Yes.
Okay, I just want to make sure I'm looking at the right piece of paper. All right, Ms. Winkles, go ahead.
Yes, Your Honor. Not exactly a complete resuscitation of the facts. First, Judge Warning stated that there was so much evidence he couldn't figure out who was telling the truth and who wasn't. Second, he also stated in open court that he hadn't had the chance to read everything considering how much information was presented. We now have a third party who has no dog in this fight, and that's the GAL, who's here today to give more information. Additionally, this 4-year-old was the one that when Mr. Ramos was arrested for strangling my client on assault 2 DV, he was also arrested for reckless endangerment to children. And the reason he was arrested for that is the 4-year-old was in his arms as he was sitting on top of mother and strangling her. Mother had the 4-year-old. The 4-year-old sees all this. The fact is that the visitation and transfer was supposed to take place at the police station at LPD. LPD is the one who did not allow these children to go with dad because the 4-year-old threw such a fit. We're not talking about crying. We're talking about a 4-year-old in a complete traumatic breakdown. The fact is that I would have loved to have done this that day. I have pneumonia. I was sick. My apologies for getting it late to the court. I did give Ms. Baldwin the opportunity to respond. I did send it to her at 12:30. Her response came over to us at 1:30. We took everything to the court. At that point, it took the court 4 hours, I believe, to read. I'm not sure if the GAL put anything in. We also notified the GAL. The fact is that it would be a devastating blow to a 4-year-old that's already seen father strangling mother. And we had photos of abuse at the time. We had a video that the GALs reviewed. And at the time of the first court case, we didn't have this, where dad is berating the children and cursing at them. We have the GAL having now reviewed dad snorting cocaine as he's driving. Again, at the first hearing, there was no third-party verification. We had a snapshot of dad holding a bag of cocaine in his hand. We have evidence of bruising, medical records showing bruising. We have independent third parties. Mr. Ramos was trespassed from Fiber Federal. My client declares that he was trespassed because he was making death threats to people who were getting in the middle of their altercation that was going on. My client, at the time of the first hearing, there was none of this independent third-party verification there is now. Additionally, we supplied other police reports. This man does not just have a 20-year-old assault 4 DV. This man has been arrested for domestic violence on 3 separate occasions and convicted on them all. They were vacated at some later point in time in his attempt to get through Homeland Security. He's also currently in the process of being deported from this country due to that. There's also allegations, which we had no idea about in those police reports, about child abuse, which is completely a different topic. I won't go into more detail about that. The police reports are with your honor. The fact is that it appears that dad's on his best behavior with the older kids, but this younger child needs to have some sort of safety measure in place, reunification. The fact is, to have this child view his dad strangling his mother and then to suddenly give child to dad would be a complete, essentially complete letdown of any safety measure. The reason why we're here in court. The other thing is the DVPO has not been modified. We haven't had a hearing. What we did is allow everything to rest on this case. We agreed, we didn't have to modify the DVPO to meet this family law order, considering the amount of investigation the GAL would make in this case and not in the other case. We have photos of dad giving alcohol to his older kids that are still minors. We have so much evidence in this case, so much weight. My client also took a lie detector test, and your honor can give that weight to however much you want. But the fact is that we have so much corroborating evidence to show that dad has beaten women in the past, the present, has been absolutely vile to his own children. The fact is the older kids are so desensitized to this abuse, likely their trauma has already occurred. How we can go about fixing that, we need to think about for the future. But this 4-year-old is still somewhat of a blank slate, and the 2-year-old is still in diapers and it is not nonverbal, but less than verbal. The 4-year-old has an amazing retention of vocabulary and has the amazing ability to say what he wants. Miss Call is here today. I'd ask for a set over. Clearly, your honor can hear my voice. I just got back from the doctor. I'd ask for a set over for myself so that I can give a reasoned response. But in the interim, the fact is dad created this situation. Dad can wait another week. Miss Call is here today. I'd ask that the court talk to her, because that's what Judge Morning was missing. He clearly stated these orders are very temporary until the GAL has a chance to do somewhat of an investigation. He gave her a very small fee just to get it started. That's how we know that this was all hinging on the GAL. He said, Miss Call, how much do you need to get started? And that's why we haven't even paid the full amount, because it hasn't been entered. She's here today, Your Honor. I'd ask that she be allowed to speak to the court and say what she's found so far. She's had a couple of weeks to do an investigation. I think she's probably in the best place rather than he said, she said, although she said with a million documents behind her.
Ms. Call, can you shed any light? You are muted at the moment. Can you shed any light on where we're at today?
Yes, thank you, Your Honor. At this point in time, I've had the opportunity to meet with both parents. I've spent time with the two younger children at home with their mother, and I have spent time at school outside of either parents with the two older children. I also yesterday received a pretty troubling phone call from the oldest daughter from school because she had been instructed to call me and tell me about some things that her father was sharing with her over the weekend. I'm very concerned that these older children are being coached and coerced potentially by both parties, but right now I'm being told that Mr. Ramos has asked the oldest daughter to share some things with me. At this point in time, the recommendations that I'm prepared to make is that the visitation remain as it's currently set up, which is the two youngest children stay with their mother, in part because both of them looked at me while I sat at their dining room table and said, I do not want to see Poppy. And they were visibly scared, expressing very clearly to me without any issue that they're scared to see their father right now and don't want to. Solomon, the 4-year-old, is very clear with me about that. Obviously, the 2-year-old, that's a tougher call to make. But Solomon, the 4-year-old, is very expressive, very verbal, very clear. The two older children are very happy to spend time with their father. They miss him and want more time with him. However, I am concerned that Mr. Ramos is sharing details of this case with the children that should not be shared. Selena, the oldest daughter, has information regarding details around how much child support is being paid, cash that Mr. Ramos keeps in the vehicle that mom is now driving. She had lots of opinions and thoughts on what should happen in this case. I was very troubled by the information that was being shared with me. My further recommendations at this point is that father submit to the hair follicle test that he's been ordered to take that he has not submitted to yet. We have a lot of allegations surrounding substance abuse that has not been addressed. Mother did submit. We have her test results. Further, I'd ask that each parent be asked to submit to a psychological evaluation by a PhD level licensed professional. And further, that father have a domestic violence assessment and attend treatment as recommended by a PhD level professional. I think that there's going to be some information in those evaluations that are deeply important. I've submitted those recommendations to both attorneys. To be honest with Your Honor, those recommendations just came to them recent moments before we had court, in part because I wasn't sure we'd actually get to speak today. I was concerned we'd end up in a set over. So I wanted them to have information about what I was going to recommend going forward in the hopes that we could agree between parties that these evaluations take place. I have very real concerns on both sides of this case. At this time, my interest is in making sure that those younger children stay with their mother where they very clearly feel most safe and protected. That's where I'm at this point in time, Your Honor.
Okay. Ms. Baldwin, you had started off our discussion. Would you like to respond?
Yes, thank you. So with older children, when they come to a parent and say, hey, X and Y are happening, the response is tell the guardian ad litem. So that isn't an unusual thing. You should tell the guardian ad litem anything you want to tell them. That's the correct thing to tell children of an older age. When we talk about the 2 and the 4-year-old, everyone essentially acknowledges 2-year-old doesn't have any issues. The 4-year-old, it's 4-year-old is afraid, sitting at the dining room table of the mother in the mother's home, arguably, if not directly in the mother's presence, knowing that the mother is home. That child, 4-year-olds are not stupid in the sense that that child's not going to bite the hand that feeds it. That child is fully aware of they don't have the option of going against mom. They have no ability to self-subsist. And this is the only parent that is available to them because father's been eliminated. And that was Judge Warning's concern. Is we've eliminated father and the resource that father is and the safety net that father is. So we now have a 4-year-old who has to say or has to do because because the child doesn't have any options. So again, a lot of concerns, and especially at that age. Everybody here is saying, oh, how articulate 4-year-old is, what vocabulary is it? Or is this a 4-year-old who's been coached to use those words and to say those things because that supports mother's story? And because older children maybe don't support mother's full story, but a 4-year-old is a really easy target to manipulate. And we know that. That's why children who are 4 rarely pass Ryan hearings, because they really don't know the difference between a truth and a lie, really don't know the difference, and are very easy to manipulate. So these are why the concern is increasing, is that mother prevented access over essentially the whole month of March to that child by my client. And now essentially when that access is going to happen, now we've continued that. My client's happy to have some kind of alternative, but again, it's sort of a all or nothing situation that's being offered here. I don't think that that's reasonable. When it comes to there's all of this evidence, but most of it really doesn't hold a lot of water. Again, when it's like, oh, well, this conviction that was vacated, well, these police reports that went nowhere. Just because somebody has a police report doesn't mean that they were found guilty, doesn't mean that that evidence held any water. My client is a brown-skinned person in a pretty white county. He gets contacted more by law enforcement than other people. He recognizes that. It doesn't mean that he has more criminal behavior than other people. So again, concerns. Both of these parties have substantial evidence. There's videos on both sides. There's witnesses on both sides. There's photos on both sides. So again, that's one of the reasons why Judge Warning was like, I have a lot of concern on both sides. It isn't just hey, they have a perk of evidence and I haven't looked at it. It was, there's a lot of evidence on both sides and I have a lot of concern. So in this case, if we'd ask that the court not maintain this order, at a minimum, the two oldest should, and nobody's disputing, the two oldest should continue to go with my client. The 2-year-old should go with my client. No one's saying there's any issue with that child. Why would we prevent the visit when there's literally no issue with that child at all? The 4-year-old, at the bare minimum, there should be some type of visit that's allowed that's with an exchange that does not involve the mother at all. That can be professionally supervised. That can be some kind of soft visit that happens in a park where there's some neutral third party there. Again, my client just doesn't want to be in a position where we further and further and further entrench this sort of fear that's been created. That is my client's concern, and it's a valid one, that we just go longer and longer, and it makes things in the end harder for that child. As to the evaluations, in the long run, my client would say what's good for the goose is good for the gander, but there's a very clear reality as to cost for all of these folks. Mental health evaluations with PhD level providers, that's lovely. Those are multi-$1,000 evaluations. Domestic violence evaluations, both of these parties allege domestic violence against each other and against the children. Well, actually, my client alleges that Mrs. has directly struck the children. She does not allege that, to my knowledge, regarding my client. It would be valid to ask for those. To my knowledge, those people are not PhDs. Miss Olivia Lovely is the local person that does them. I don't believe she's a PhD. So, and I'm not sure that they're done by PhDs. So whatever the court does, orders as far as evaluations, they should just be, frankly, as to both, because the concerns are, frankly, as to both. But I have real concerns about the dollars involved as to both of these folks. My client was initially ordered to pay many thousands of dollars. He has struggled to do that. He has put paying his obligations to mother towards the mortgage that was court ordered to maintain the family, or not mortgage, to the rent for mother, to support for her, to daycare for the child, to paying all of those things. Those have been the priority for him, and making sure all of those things got done. So he put those first, and he recognizes those had to be sort of put first before he paid for anything else.
Right.
Any response from me, Your Honor?
I'm sorry?
Can I do a brief response?
Brief response. Go ahead.
The fact is that Dad has almost an unlimited supply of cash. As we've stated, Dad has a side job of selling drugs. Again, videos were provided to Miss Gall. Mom found the way to pay me through cash, just tens of thousands of dollars just sitting in a car. Just one of the vehicles that were paid in cash. This man has Mercedes, Jaguars, BMWs, all very new models, all paid in cash. Dad has enough money to get these evaluations. Mom has never been tried and convicted by a jury of his peers or of her peers for assault. Dad has. Whether or not Dad got vacated, it doesn't matter. Dad was convicted of them on appeal. He lost. He did appeal one. He lost. His conviction stood until he vacated them years later. The fact is, Dad also came to this court back in 2015 claiming he was sober. We submitted that declaration, yet Dad had a DUI he failed to disclose to the court only months before. The veracity and credibility of Dad is very, very little. The credibility of Mom has never been impugned, except for by Dad and some third-party declarant neighbor that claimed he saw Mom outside screaming and muttering to herself. That's about the extent of it. Dad's entire argument is that Mom is crazy. We have videos that show pretty much everything that we've stated. We provided screenshots. We have police report after police report after police report going all the way back to 2011. We have police reports from other matters involving other women. We have everything that anyone could ever ask for, including including medical records that day, and where mother didn't even press charges, stating in 2011, 2012, 2014, dad beat me up, dad did this, yet she stays with the man. If she has a mental health issue, it's the fact that she stayed with an abuser. There's nothing else that dad has supplied. And dad wanted this hair follicle so badly. He paid for mom's, yet he doesn't take one. Mom does, and mom passes. Mom's clean. Dad doesn't take one, waits long enough to where, oh, lo and behold, now we're clean. It's a bit shocking that dad was able to get any visitation to start with. However, it appears the older children, again, desensitized, want visitation with dad. The younger children, both of them, not just one of them, both of them have indicated they do not feel safe with dad. The fact is, dad created this. This is not mom coaching. This is dad sitting on top of mom, beating her with a closed fist and then strangling her while he sat on top of her while the child was in her arms. The police come. He claims it was all mom hitting herself. You can read the police report. And they say there's no way those marks were made. And that is a signed declaration under penalty of perjury. There is no way that mom could have strangled herself with her hands and show the marks that she did. You can see the bruise, massive bruise on the side of her face where she was pummeled over and over again. You can see the bruises all over her body. You can see them go from January, April, back, just bruises covering herself. The fact is that these children are actually in a very unsafe situation with dad. The fact is that dad is probably most likely on his best behavior, which is the only reason I'm not arguing today for no visitation until dad has treatment. Dad was ordered back in 2015 to undergo batterer's treatment. He failed to do it. He keeps getting away with this, and somebody keeps getting more and more injured. All it takes is one little slap to a 2-year-old, and that's the end of the story. And dad's not here legally. So the recourses of this court are very limited in that case. These kids need to be protected. 1 week, 2 weeks is not going to ruin dad, is not going to turn the tides and make suddenly these kids hate a man that they loved 2 weeks before. But what it can do is protect these children for the next 14 days until the guardian ad litem can do more. And it can protect them until more is done, until psychological evaluation is done. This court does not want to hand these kids over to dad, who has already threatened to flee to Mexico. They don't want to hand these kids over where something bad might happen when the dad only had to wait 14 days. This isn't about the best interests of dad. This isn't about dad. This is about the best interests of the children. And that is to be protected until somebody can figure out what's going on. Olivia Lovely was the person in charge of the last hearing back in 2015 where dad, I guess dad did go through a week of treatment or something like that. We'd ask that it be somebody else this time. There are other providers, somebody brand new. Where mom has a chance and there's no other females that were already there. So that's what we're asking for. PhD seems appropriate. Dr. Maharg is one of those providers that is there available. I believe mom has already engaged Dr. Maharg for that very purpose. Dad can too. I don't think that's an issue, but at least the court will have somebody, Dr. Maharg's opinion of what really is going on here. I think that's vital to this before we hand over a 2-year-old and a 4-year-old that really can't protect themselves.
I'll just make clear that the immigration arguments are not proper. That they're nowhere in the law does status allowed to be part of the decision.
Thank you. All right. I was going to raise that comment myself. Immigration status on any court hearing in Washington State is really inappropriate. So please do not, I don't want to hear that anymore in this courtroom. That's not an issue the court's going to consider, whether it's true or not. It's just not appropriate. So I guess what I'm concerned about, I've had the probably more opportunity to review the documents in this case, not as many the most current because I did a protection order hearing. So I reviewed this case a number of times. So, and I can say after review of a lot of information, it's not 100% clear to me what all is happening and what all are the facts. I know there are certainly some concerning behaviors concerning to the court. What I think is swaying me today, in the reason, well, first I'll tell you what I'm going to do. I'll tell you why. I am going to pull the 2 younger kids out of the visits on a temporary basis. First off, I don't know that we can have the evaluations that are being suggested in 2 weeks. And I guess I'd like to see a more detailed report as to the basis of that. I'm not sure that having a psychological evaluation is going to have all that much impact on what court has to do, frankly. They may be useful for certain things, but depending on who does it, what it's for, what the parameters are, it may or may not help the court. But my concern really, and I look at the fact that I have, and again, this is an allegation purely, but I have an information that specifically lists the 4-year-old as being part of a criminal case. and it's, and I understand this is an unusual case where there were some, I think it was Judge Evans heard that hearing, but there was at least some indication that, go ahead and change the protection order in the criminal case. It's highly unusual in the middle of a case of that significance, but I'm not second guessing those decisions. But I am going to pull the two younger kids out, and at least at this point, certainly can reconsider that once Ms. Call's had more time to dig into this a bit more. I think that both counsel, you need to talk to your clients. These kids do not need to be involved in discussions about this case at all. They don't need to know what's going on, because whatever trauma may have already happened, this is simply redoes that, and that's just not appropriate for kids. So the order that was entered on the was it the 11th or the 15th? I think it's the 15th. Get the right page here.
The 15th.
15th. That'll remain in full force in effect, except that the two younger kids, Solomon and Benjamin, I'm going to pull out of that order, and they'll be. I don't have any huge issue if they want to have maybe once a week a video chat or something, but I think at this point I'm going to pull them out. So, are there other issues that need to be argued at this point, or are we just you want to set the rest of the issues out?
If we can set the rest of the issues out, that'd be great for me, but Ms. Baldwin may have a different take.
No, the rest of the issues. So the order, I'm sorry, I just want to clarify, when you're saying going to pull the younger two, but potentially do some sort of video visit, is that the court's intention with the two younger children?
Yeah, if they want to have a weekly video chat with the younger ones. And again, I know a 4-year-old and 2-year-old, if they don't want to do it, they don't have to do it. But I think that give them that opportunity at least.
We ask that be professionally supervised. My concern is that if it's with mother in mother's house, it'll just never happen, that the children really won't be given that opportunity. So we'd like that to be at either utilizing essentially a visit coordinator or a professional supervision agency, so the children can actually have the opportunity to have that happen.
I don't want it to happen.
And my question would be, who would pay for that? How would we set that up? How long would it take? If Miss Call, I know she needs to see dad with the kids. Maybe that's something Miss Call can do, because we're only talking about a 2-week set over. Maybe we do it once with Miss Call present. That might be a way that we could see dad with the two kids as well.
Ms. Call, do you see that as helpful to your investigation?
I believe so. Yes, I will tell Your Honor, I'm not sure that Solomon will participate in a conversation with his dad, but if we're able to make that happen, I'm happy to be present and a part of that.
And I'm not ordering Solomon to participate. I'm just the opportunity to be there, obviously. So I think I guess the parties can coordinate with Ms. Call to do that. I think that actually is a really good idea. That's probably very helpful.
And I just ask that it not be at mother's home. If it's at mother's home, I think then children feel pressure to not participate.
I think that's probably a good thing. I don't know, do you have an office that they can go to, or would there be?
They can also go to my office. We can stick them in a conference room.
Yeah, just someplace else. That's fine. Okay. Any other issues? I guess what I'd like to do then, do you want to go at 2 weeks on this or one?
Yeah, 2 weeks would be great for me, Your Honor.
That takes us weeks after.
Your Honor, sorry to be crass, but can we address the remainder of my fee as well, so I can continue investigating? I've almost hit the amount of time.
Ms. Call so the original order for Ms. Call was only like $1,000, I think. It is reasonable that the remainder of her fee be paid. My client was ordered to pay, I think, the entirety of that initial $1,000. I would just ask that the remaining portion be 50-50 between the parties. According to Ms. Winkles, her client received tens of thousands of dollars from the community vehicle, so it's reasonable that they split Ms. Call's remaining fee.
My clients paid attorney fees with the money that she found. Those attorney fees, given the amount of times we've been here, have ended 3 hearings. 3 different matters have already been spent. My client has 0 job. She's on TANF. So it would be appropriate for her share to be county pay, given that she's on TANF and food stamps.
What was the original order? I mean, the order, I know that Judge Warning ordered $1,000. We paid immediately to get things going. That wasn't the order as to her fee.
So there is an order appointing guardian ad litem. And
right,
so there's 2. Okay. Yeah, there's an amended one. Look at the amended.
I just have the one from 315.
Yes, 315,
Mhm.
and it's on page.
Yeah, so it's
Four.
3,300 max.
Yes,
1,000
but
legally with 2,000 remaining.
yes, and you're to decide who pays the 2,000 today.
Okay.
And to be clear, Your Honor, he actually paid me 1,100, just to be clear about that.
Okay.
And again, my client's on TANF and food stamps, and any money she found in the car has gone to my fee.
All right. Well, I guess, and not having done the math on these before, if you're part at county and part at private, does that change the fee, or how does that?
I've had this happen in the past. What I do is just calculate whatever that cap number is and
Mhm.
divide it down the middle. I mean, if, because the county fee is considerably less than a private pay fee, I just try to do the best math I can. These cases tend to use quite a number more hours than are allotted. But I try to do the best I can to be ethical and have those numbers match.
So let me do this. I think what I'm going to put mom's at county pay. I'm going to leave his at private pay. So split that number up according to your normal formula. I'm also recognizing this is a case where I'll see some requests for additional fees, and those will certainly be appropriate, I think, in this case.
Thank
So
you.
your intention is to 50-50 the remaining mom's county pay, and then we'll figure out the math for Mr.'s.
Yeah.
Okay.
Yeah.
All right, very good.
I don't do math in public on the docket.
It's fair. I don't either.
I try not to either, Your Honor.
So, but obviously your fees is what it's supposed to be. So, okay. And again, if you do need additional fees, I expect this is a case that'll probably be a bit more work than a typical one. So I wouldn't be surprised. Okay.
I expect that's true. Thank you, Your Honor.
All right.
All right,
So
thank
put
you.
the balance this over 1 or 2 weeks, over the 9th of April. And what I would ask counsel, I don't need a whole lot more filings, but if either of you could submit me like a 1-page document as to the specific remaining issues you want me to look at. So when I come back and review this for 2 weeks from now, I will be able to isolate what the focus is.
And respectfully, I'd like to respond. They didn't provide me this motion until 1 o'clock. Literally, we wrote the response blind.
You can certainly, if you want to respond more, I'm fine with that.
Yeah.
But if I don't need it, I just want to focus in on what it is out of this gigantic file that I have.
Bear with me. Made this too big. Can you?
What I need to focus on, that'd be helpful.
Okay.
Very good.
Okay.
All right. Thank you, Your Honor.
And I can, if you can't agree on an order, we can put it on for next week for presentation if you want.
I'm hopeful we can be fine.
Present. Okay.
I think we can come up with something. Thank you.
Mr. Phelps should be present in the courtroom, Your Honor.
He is. If you want to sit at the table, you can, sir. If you want to sit a little closer, you don't have to, but. Okay, so this is on for a motion. I guess my question on this, and I didn't find it in any of the documentation. This is a case that's supposed to go to counseling or mediation or something before it ever comes to court. So did that happen? Counsel?
No, Your Honor, the parties have been trying to communicate and it's not really gone anywhere.
Okay, well, they're supposed to do that before they're here in court.
Let me look at their, let me pull their parenting plan. I didn't see that, Your Honor. But
December 18th order.
let me pull that.
This seems like, at least as far as that goes, it seems like a case that probably through the mediation would probably make sense.
One would hope, but the parties have tried before and hasn't gone anywhere. But I also understand what they need to do. Let me pull up. I didn't see that, Your Honor, but let me look at the.
It's number 6. It's on page 5 of the December 18th order.
And my client's there, Your Honor, so he could also testify, or not testify, but if you wanted to inquire of his attempts to get her to mediation, because that is not in our pleadings.
Did you guys try to do that?
Did we what?
Did you go to mediation or attempt to do that?
No.
Okay. So I think given the order that's in place, I think that probably needs to happen before, this clearly is not an emergency under the order. It's been going on at least since 19. So my inclination today is to deny the motion, any motions, have the parties, if you didn't, to either go through mediation or counseling. It looks like they've got Counseling check and through refresh therapy, if that's not available. I mean, counseling or the mediation center locally or some other would certainly be fine, but I think that needs to be attempted first.
Yes, I with refresh therapy, Your Honor, just personal knowledge, it's very hard to get into, but I would agree, like community mediation services or another DRC.
I mean,
Even
we
the
have,
DRC in Clark.
yeah, there's one in Clark, there's one in Cowlitz, and I think there's one in Lewis as well. So whatever the parties want to try, but my inclination today is not make any changes until that's done. And then if you want to note it back on after that's been completed, if it's not successful, then we can certainly look at it.
Your Honor,
Yes,
my
ma'am.
name is
Thank you.
Veltz, and I am representing myself.
Mhm.
I did actually ask him prior, and I did some research and found the pricing and whatnot for mediation, and he denied it. Before this came to court, it was not my choice to bring this to court. I offered mediation to him and what the pricing of it would be, and he said no.
I know they have
You know-
they have sliding scale pricing. I know that, so it's not really expensive.
No, the community mediation, Your Honor, I think is 300 something for 2 hours, split by both parties.
Hmm.
So I can communicate with Mr. Feltz and send that to Mrs. Feltz, and hopefully we can get an agreement for her to attend. If not, we will note it back on.
Okay.
Perfect.
Yeah.
Thank you, Your Honor.
I realize that doesn't fully answer your question. For purposes of court, my name is Kevin Curtin. I'm an attorney here on the Gall v. Gall matter. I represent the respondent, Jesse M. Gall. I filed a notice of appearance. I had to mail it because I'm in King County. I mailed a notice of appearance, and my understanding is it made it into the court file yesterday. I also sent a copy to the opposing party, Mr. Gall. Today, I sent a copy to Ms. Looney, who works for the state, and Ms. Corey, who is the GAL. So I believe everybody has at least received the notice of appearance.
Okay, and I do see your name. I do see your name here, so apparently we got it filed. So,
Mr. Curtin, there is one more person you may want to notify, and that is Ms. Charlotte Rosen. She's the
Ms. Rosen, yes.
Yeah.
I went to Ms. Rosen's website today to try and get an email address. I couldn't get an email address to send it to her. I left a call and a voicemail, and I'll be checking that after this hearing, but I assume she'll direct me to either fax it or email it to her today, and I'll take care of that this afternoon.
I'm happy to help introduce you, sir, and welcome to this matter.
okay, so this was, I believe, just on for a GAL interim report, which I have received. See, Ms. Corey is present. So I think that really today was to put that on. It says, I don't know, I'm not sure why it's saying review temporary orders because I don't see any motion in the file for today.
There are no motions, Your Honor. Your Honor had granted me the ability to explore the option of requesting a lower child support because of the financial strains I'm experiencing, but Commissioner Kearney denied me after you had scheduled me, Your Honor. So not sure what motions would be in place.
Okay, well, there is, like I said, there's a guardian ad litem report that I think I need a motion if I'm going to move forward on that today. I typically just come on for review to make sure that they're done, and then if additional time is needed, it looks like Ms. Corey got it done timely. Thank you. So at this point, unless someone files a motion, I don't have anything else on this case today. I know there are some concerns in the report, so that's probably be appropriate to look at that.
I do have a few items to discuss, Your Honor. It turns out that when we selected Ms. Corey again, I may have logged off the call too soon. It had taken me some time to ask my employer for an advance to pay her fees. And my employer finally granted me an advance to pay her fees. But as it turns out, I was not aware that her fees had increased. It was my impression that her fees were the same as the last time, the first time around, which were $750. I had a hard time attaining that amount, and finally my boss allowed me to borrow it. I forwarded that amount to her, and last week Ms. Corey contacted me. She said that her fee schedule has changed, unbeknownst to me. It's probably my fault for not having an attorney or having the money to have an attorney. But I was not aware that her fees had increased to $3,300 and that I was responsible for half of that, or something to that effect, or around those. Ms. Corey, can you specify?
Well, I'm just looking at the order that's in the file. Which it looks like it'd be 1485, is that?
Yeah, so that for some reason that completely escaped me, and I don't know how, Your Honor. I'm currently recovering from being ill. My request, Your Honor, is I was wondering, is it possible for the court to allow the remaining balance, which is like $735, I believe? Would the court please consider paying that from the funds that are in escrow with the court so that Ms. Corey can be made current with the fees? I asked Ms. Corey if she would take a credit card, and she does not take credit. There's just no other way.
Well, first off, before I make any, I don't know enough about all the finances in the case to make that decision today. If you wanted to file a motion, I certainly can take a look at it, but that both parties need to be able to see that motion and understand it.
Got it.
But you're certainly welcome to note it on. I'd be happy to look at it.
Okay.
And at this point, we're not stopping the case because you owe some money at this point, obviously.
Yeah.
And we'll work through that. That will need to be taken care of unless we make some different orders. So.
Understood.
Okay.
Thank you.
All right. Anything else today on this one?
If I may, Your Honor,
yes.
Just a few minutes of the court's time.
Sure.
If I could, does the court's bailiff have an email address that I can use when I'm trying to communicate with the court? And I'm asking because, like I said, I'm situated in King County, and when I mailed my notice of appearance, it took a week to get from Seattle to the court. And this is set for trial in June. We're not going to be moving forward on anything with the GAL report today because she didn't have any recommendations yet. So there's nothing to be addressed there as far as I can tell today. The court's temporary order that was issued on January 12th, it appears that it appoints the GAL, and everything else appears to be up to date. I think everybody's in compliance with the order that was issued on January 12th of 2024 in terms of Ms. Wickles' notice of withdrawal, my notice of appearance, how to set up the GAL. The GAL was ordered. So I don't know that there's any temporary orders where there's any issues remaining with the temporary orders. But in case I want to communicate with the court, something faster than postal mail would be helpful. And also, I noted in my court, I know in an abundance of caution, I wrote in my notice of appearance that I would not be able to make physical appearances and that I would be requesting that everything be handled by Zoom. I realize that's the court's normal practice, but I just wanted to be clear on that personally because I don't want to delay anything in this case. It's a 2-year-old case already, and I'm sure we don't want unnecessary continuances because I was not fully informed about the court practices. So I just wanted to verify that as well.
No, you're fine. I recall that question having come in myself, and we did understand that this would be a Zoom case essentially, which is fine. Is it just 1 second? It's just Superior Court Administration. Yeah. So if you just send an email, if you go to our website and go to the administration tab under contact us, it's got our court administrator as well as other staff.
Okay.
But you can also send an email to Superior Court Administration, all one word, at calitz.wa.gov. Just our email addresses. And that gets to all of our staff. So if you have questions or something, but if you go to the contact us on our website, it's got all that information, how to get a hold of us. And
Understood.
So you can get your questions answered. And then if you do need to get something quickly, they can give you some instructions how to do that.
I appreciate that, Your Honor. I have one last question. Sure. I noticed it doesn't appear that there's a protection order case that's separate from this, and it doesn't appear that those cases were in any way consolidated. Is that something the court would want to consider? Because one's going to impact on the other, and it seems more sensible to try and address them both on the same calendar at the same time. It avoids multiple appearances from the parties, et cetera. But if consolidation is not in the picture, then we can do it on a bifurcated basis. But since any findings of one might impact the other, I thought maybe consolidating the two of them might be wise at this point.
Just from a process standpoint, we generally don't consolidate two different types of case numbers. One's civil, one's domestic. They can be related to one another, but they're typically done separately. You may want to contact the court clerk to see what their position on that, because they're the ones who manage all of that, although we would make those orders if in fact they were okay with doing that.
Understood.
Yeah, normally they don't consolidate two different case types, like a 1 and 2.
I understand.
Okay.
I have no other questions at this time.
Your Honor, if I may just provide some background for Mr. Curtin in regards to that question.
I'm gonna let you guys do that offline because we have other people waiting for court. So
understood, Your Honor. Thank you.
Okay. All right, and you feel free, you can email each other all you want to on your own time.
Yeah, it's been a breath of fresh air. Thank you, Your Honor.
Okay. All right, so that should be all for today. Let me just double check and make sure. I know we have some other hearings set in this case at some point. It's like,
Would it be possible for me to just, and again, it's because, A, I'm practicing remotely and I don't see a way for me to be able to find this online. So could I just verify verbally now the next couple of court appearances so that I make sure I miss any deadlines?
that's what I was going to do right now. I show a review hearing for a final guardian report on April 23rd.
Okay.
That'd be on this docket at 1 o'clock. I show a May 28th readiness hearing, which would be 11:30 in the morning. That's a readiness. It'll be on our website. You can go to our Zoom hearings and it'll have a link to it.
Okay.
And then on June 3rd, I have it set for a 3-day trial. So that's what's currently scheduled. If you do have access to Odyssey portal, you should be able to, because we're an Odyssey court, so you should be able to access anything from our court file that you can access on any Odyssey court.
Perfect. I will try that. And thank you for verifying those dates, Your Honor. I appreciate it.
All right. Anything else today?
Thank you, Your Honor.
I've got a number of things set, but I don't. Did you serve that order to show cause on anybody?
Yeah, I believe so. My wife did, I believe.
No, I don't.
Miss Baldwin, I believe, or the court. We haven't received anything back from them.
Did you?
When you're ready, Your Honor.
Yeah, go ahead. I've got a lot of stuff pending on this case, I know, but this was the order to show cause from March 6th, I think.
We haven't been served anything. So in this case, Willie noticed we happened to cruise through the docket and see that this case was on, looked it up in Odyssey, and surprise, surprise, found a number of things were on over the next couple of weeks that none of which we've been served with. So in this case, we just simply haven't been served. CR60s require a specific kind of service. That certainly hasn't happened. We're just asking the court to strike and award fees. In this case, I'd asked for half an hour of fees. I was here for other cases, but also here for this. Half hour is about $260 of my time.
What I'm looking at in the court file, just from our record, I show an affidavit of service on March 20th, a couple days ago. A notice of hearing for April 2nd, and then I'm not sure what all those are, a number of different things. So I don't have any proof that this was ever served on your office for this hearing.
This hearing was for the, when I didn't show up to court. Supposedly, I was here though, Your Honor. I just couldn't get on Zoom but I was in this courtroom on the young lady here. We talked.
Okay, well, here's the problem.
Yeah,
you put it on for an order to show cause, but you have to serve Ms. Baldwin that order.
I believe that she's been served.
Well, I don't have any proof of
okay, on which order are we talking about?
The one that set today's hearing.
Today's hearing was for the,
this has to do with vacate the 11-9 order, which I think is the.
That's the bench order that was when he failed to show for the MSC.
Right. Right. That's what that's about.
oh, I didn't know there was, I just thought I had to come to court today and talk to you over this matter because
No, it's a hearing, so you'd have to serve her.
Okay.
And then she can respond to it, and then we can make an order.
Okay.
So you can certainly note it on for another hearing down the line, but I can't address it today.
Okay.
As I think I'm going to reserve on fees that certainly can be raised. I know we've got a number of hearings coming up, and I'll deal with those all together. So if you want to remind when that comes forward, I'll address that.
Very good.
Okay. So I'm not going to issue an order. If you want to bring it back on, serve Ms. Baldwin timely, and we'll be.
Oh, okay. I didn't understand. I thought this was done through the court. That I talked to you today.
That's a court record that came out of a hearing, so it has to do with the other side. So anything you come to court, talk about the judge about, we need to have noticed to the other side.
Okay.
Sorry,
Ms. Baldwin, I didn't know.
Okay, well, what I'm going to suggest there too, but before you file a lot of documents, make sure you get some legal advice because you can get yourself into trouble.
I'm trying my best.
Okay. Well, if you come to the courthouse, I believe every Monday there are some lawyers out here you can chat with. They don't cost anything. They give you some direction. That may help keep you. I
tried to talk to the over there by the 14th, but my previous Ms. Roush has talked to everyone.
Okay, but if you come in, like I said, they're here and they're available for questions.
Okay.
Okay.
I appreciate that.
All right, so strike today and I'll reserve on fees. I said over because last week, Ms. Tina had filed her
Okay.
declaration. I'd not have seen it because it hadn't come through. I had an opportunity to review that and take a look at the support numbers. Based on the limitations that exist for folks in her situation with that income, it's basically a limitation that's put on by the state. So what the order would be, and this would be effective for March 1st. So, but I'll need to have you prepare an order, sir. It's $50 per child with $100 a month total. So that's what the number calculates out to, at least at this time on a temporary basis. Okay?
Yes, sir.
Yeah, my only concern is that Samantha is self-employed. So the income she receives is hard to verify
Okay.
through your standard pace.
You can certainly bring that up when we get to a more permanent order, sir. But at this juncture, based
Okay.
on what I have, that's the order I'm making.
Understandable, Your Honor.
Okay, and again, we'll certainly look at it. If we have additional information as we move forward, we'll review that.
Yes, sir. And this may sound like a dumb question. How am I intended to receive those funds?
First off, I need to have you prepare a written order that says that's the amount, and you use the standard form that's available on the State of Washington website or from the clerk's office. They can get you a child support order. I don't need a worksheet necessarily for this, but I do need a written order. So you'll need to put that together, send a copy to her, and I can put this on the docket for entry. I can put it out 2 weeks. That'll give you some time to put it together and both take a look at it. Does that work?
Yeah, so
You just download the form and you just go through and fill it all out, and you can have that paid directly. Probably better if you pay it through support enforcement, and they'll take care of it and they'll keep track of all the payments.
okay. And what does the form have a name?
It's just a child support order. It'd be a temporary child support order.
Temporary child support order.
Yep.
Okay.
Your Honor, may I ask a question?
Yes.
Would you be able to modify the supervised visits? I have a peer support that's a part of my treatment who said that she could potentially do supervised visits. That way it could save me some money. That way I could afford his child support as well as my rent.
Well, I'd be happy to consider that, but I need to have you file a motion with a declaration as to what you want to do and all that information.
Okay.
Serve that so he's got an opportunity to respond to it, and I'll be happy to look at it.
Absolutely. Thank you so much. I'll do that.
Yep. And if we have a guardian, I believe, Miss Lawrence, so you should serve her a copy of that motion too.
Okay.
Yeah, I haven't done as much on the back end of this case, but if you want to file a motion, I'd be happy to look at it.
Okay. Thank you, sir.
Okay. So I'll put this on 2 weeks from today, 1 o'clock for entry of a child support. It'll be the 9th of April. If the two of you, if you put the order together and you both agree on it, you both sign off, you can just drop it off the clerk's office and wouldn't have to be here on that day. But if not, I'll need it by the 9th.
How are we supposed to wait? We're supposed to agree. What do you mean?
He's going to put the order together. It says it's $100 a month.
And it'll be
$50 per
served to
child.
me?
Send it to you. If you agree that's what it looks right, you can both sign that and just bring it to the court.
Okay. Do I have permission to send him my address? I don't think he has my new address.
If you want to.
Okay.
Yeah. Any problem with that, sir?
I would, if at Your Honor's grace, I would request to do it electronic. I mean, I would like her address because, you know, in whatever future moments when she is visiting the kids, but I would request for electronic service because I've had a lot of difficulty serving her documents in the past. I had professional service paid for, and it took about over a month to finally get her to serve the documents.
Okay. Would you agree to electronic service of documents?
Oh, yeah, that's fine.
Okay. So, and you have his email?
Yes.
Okay. So here's what I want you to do. You send him an email with your contact information. And then if you want to put in there that I agree to accept service by email, then you can file that with a cover sheet with the clerk's office that you both agree to that. And then that'll be the rules going forward. You can serve each other by email then.
Okay. Thank you, Your Honor.
Okay.
Okay, so I would have to serve something to the clerk's office saying that we agree to electronic service.
Right. When you get the email from her, put that on with a court cover sheet with this case and bring it to the clerk's office. So we have a record in the court file that you both agreed to do that. And then that works perfectly well.
I have two more questions.
Okay.
So court in 2
2 weeks on the 9th.
and then back support for the 1st of March. Is there any way we could do it like the middle? Because that's when rent's due. And so,
Well, I mean, it's going to be for the month of March, you'll $100.
okay,
And how that gets paid is between you and he and court enforcement.
okay.
Okay.
Thank you, Your Honor.
All right. We'll see you in 2 weeks, hopefully with an order. Okay.
I will do my best, Your
I
Honor.
guess I'm not, okay.
Thank you.
Clear what we're doing today because I don't have proposed orders, but I have objections to proposed orders.
We sent in our proposed orders last week. Let me double check that.
Wait a minute. Hold on.
It's just the temporary family law order.
Okay, I do see that. My mistake.
Okay, that scared me a little bit.
Hold on a second here. I'm looking at a different thing. Just a minute here. Somehow that got confused with a different document. So, okay. Mr. Zandy, are you still here?
Yeah, I'm here.
Okay. You must be over on my other page. There you are. Okay. All right. So I have the temporary orders. I have some objections. So let's talk about those.
Yeah,
Sure.
just a few quick objections, Judge. I think clarification. I went through and reviewed my notes. I also went through and looked at the clerk's minutes. Working backwards, the first relates to this Bahamas trip. I had competing notes, and I think unfortunately the clerk's minutes did too. So I just need some clarification, make sure everybody's on board with this. My client is not anticipating going on the trip to the Bahamas in late April. I guess with that said, does the child go or not? I guess that's the easiest way to ask that. And that would be the clarification. That's first and foremost. And then second of all, we're asking for some clarification on the schedule itself. This is the case where we're heading to mediation here in a couple of days. So hopefully this is a moot point. We can resolve this, but nonetheless, I think it's probably better safe than sorry to include some specific visitation for both parties, which is the equivalent of the joint plan that you ordered a couple of weeks ago, that we've suggested some language for that. So those are the two issues.
And I guess what we will do, we can start with the Bahamas trip. From the objections filed by Mr. Zandy, as far as the letter to the Bahamas trip is concerned, the court really did not make a specific ruling regarding the letter. We did indicate in both our pleadings and in our oral arguments that we received instructions from the airline that opposing party will have to write a letter for the airline stating that he approves the child traveling with his mother. In following up with the airline's post-hearing, Ms. Bennett was told she actually didn't need a letter. And we did pass that information on to Mr. Zandy. We did receive word from opposing party that he will not be going to Bahamas. So perhaps the safest thing with the conflicting instructions to do is have a letter drafted and even notarized in which the father states something along the lines of, he is the father of the child. He is aware that the child is traveling to the Bahamas with mother and that he gives permission for the child to travel to the Bahamas with his mother. If the court does, if the court does need those specific instructions to be interlineated, that's fine with us. At this point in the game, we do just want to try and prevent any issues from popping up. As far as the first objection, we pulled the exact language you used for your ruling. We did receive a copy of the recording and we put it directly into the temporary family law order. You stated that neither party's parent or proposed parenting plan is ordered. The parties have a 50-50 parenting plan based off their work schedules. That's what the ruling is. That's what the order says. The court wanted to give the parties an opportunity to sort the parenting plan out at our upcoming mediation. Your Honor, mediation is this Friday. I find it difficult to believe that coming here today and perhaps having you interlineate an entire parenting plan that was not previously set out is a good use of the court's time and resources, especially in light of the fact that this plan would be in place for less than 4 days. 4 days, we note that opposing party is working while my client is off work. Ergo, the child would be with my client based on the party's work schedules. We'd also note that the proposal submitted by opposing party actually does conflict with opposing parties' own work schedule. For example, on week 2, mom is to pick the child up Tuesdays at noon. Dad works Tuesday from 4:30 a.m. to 2 p.m. while mom has the entire day of Tuesday off. So why is mom picking up the child at noon? Who has the child Tuesday from 4:30 to noon? Because again, dad is at work, mom's not. My client isn't working, so why isn't the child not with his mother? So even if we weren't going to mediations in 4 days, this proposal does not adhere to the court's order of a parenting plan based on the parents' work schedules. So the crux of it is, this is going to be a logistics thing. We all noted that these are good parents. They're trying to get this all sorted out by their work schedules. If it's going to be a matter of, okay, picking up here and dropping off there, again, the court didn't make any specific rulings about that. So the court, I believe, is giving us the opportunity to sort out those details this Friday. And I think that is a better use of everybody's time and energy.
Well, and that's fantastic and all, and I'm not asking for a parenting plan, but some kind of a schedule is necessary. I mean, joint means equal time. So what is the equal time? As I think everybody knows, council included, court counts the overnights when it comes to a joint plan. So what we're proposing does that, and it coincides with work schedules as best as possible, knowing that there's no ideal solution for that. So it is what it is. Arguments also suppose that we're going to be making a resolution on Friday, and although I certainly am optimistic and hope for that, there's very far less than certainty that's going to happen. So having something to fall back on, as opposed to coming back to court in another couple of weeks because there's uncertainty and no clarity to that, that would not be the best use of the court's time. We're here on presentation. Court didn't specify outside of wants to keep that as joint and equal as possible. I think we've done that. I think it's kind of in line with what both parties were proposing with a couple of tweaks, and I think it makes sense moving forward. Second of all, to that, if you look at the clerk's minutes for this Bahamas trip, court says in one section, court authorizes trip as long as both parties are able to go. And while they are there, they have 50-50 time with the child. And then in the second section, it says child is allowed to go on trip with mother, even if father does not go. So those seem to be at somewhat odds with each other. I don't care. I just want to know what to expect moving forward. My client's in the same position. So it is, in contrast to just having some open-ended order or ruling, just ask for a little bit of certainty to be put in place there, and in hopes that we can resolve this on Friday, but certainly there's no guarantee of that.
And Your Honor, if I may, Mr. Zandy, you did ask that clarifying question. What if dad doesn't want to go to the Bahamas? And I believe, Judge, you answered the child still goes to the Bahamas. And I am looking at the transcript of the recording right now, and that is confirmed in the transcript.
The Bahamas trip, I mean, having traveled with a 2-week-old to a much older child, it's a long flight to southern Florida, and it's a longer flight to the Bahamas with a child on your lap or however you do that. But that being said, and I can tell you my own son, he's been places when he was 3 and 4 years old and doesn't remember those places. So I guess my feeling on it is that I mean, both parties have tickets to go. There's no reason they both can't go. What I think I'll do at this juncture, I'll authorize the trip so long as both parties are able to go. It sounds like the tickets are available. And while they're there, they have 50-50 time with the child. So they don't have to spend it together, but the child is 50-50. If you want, I think it's probably as far as I'm going to go. If you want, I can either appoint a court investigator to look into this a little bit more, or do you want to go to mediation first?
So if I'm understanding, the trip to Bahamas can happen for the child, provided both parties can make that work and both parties go. If both parties do not go for whatever reason, then the child stays here.
No, the child goes on the trip. He can go along and he has half the time of the trip with the child.
Okay.
So, I mean, you're both going to want half the time with the child, because otherwise you're not going to have much of a vacation in the Bahamas.
And if we wanted to come up to with an agreement, if
you guys can
beyond that,
you can agree to anything you want to. I don't know,
right.
That's what I'm going to do.
That might be a discussion for Mr. Zandy and myself, but yes, thank you.
And I'm not going to get in the way of that.
Right.
You don't need to tell me you can address the court, but I made my pitch, Judge.
All right. Well, I'm looking at the clerk's notes, which this would be me responding that the child's allowed to go on the trip with mother even if father does not go.
Correct. And then in the section above that, it says the child can go as long as both parties are able to go.
Where?
2 paragraphs above that. Court authorizes trip as long as both parties are able to go, and while they're there, they have 50-50 time with the child while they're.
Okay.
So if that was your intention, that's fine. I don't disagree with that lady.
Well, my intention was based on the information I had we had tickets for both of them. And they would both basically can go to the trip. They both can go. And if they both go, they get 50-50 time with the child while they're there. That was my expectation. And then later, if he decides he didn't want to go, then the child still can go.
Okay. That's the only clarification needed on that. Thank you.
So if he wants to go, he goes. He has 50-50 time. If he doesn't want to go, they don't have to be together. I mean, other than on the plane, I suppose. But I mean, but he can go and do whatever he wants to for the other 50% of the time.
Sure.
So I mean, and that was kind of what it seems to me. You've got tickets. It's and I didn't use them up. As far as the schedule, I guess my intent was because I didn't lay everything out on a grid to see who was where. My expectation would be knowing that not all parties. We're not going to have a situation where every time one party's working, the other one's not working necessarily. I mean, there's going to be probably some overlap of that, but generally, if somebody's working, child should be with the other parent for the most part. And I don't know what that looks like without laying out a grid. And my hope would be that my hope was you'd go and sit down at mediation and be able to actually lay that out and kind of come up with a plan that actually is flexible enough to work. Because people's work schedules may change in the future, and hopefully this plan will be able to flex with that. I mean, a joint plan is not by definition a 50-50 plan, but it tries to be. If that makes sense.
So fingers crossed for Friday, then we'll just go there and hope we can iron that out.
I'm the eternal optimist. I have a lot of faith in people.
All right, we'll do that then.
And so,
okay, thank you.
Are we, as far, just real quick, the objection regarding the letter to the Bahamas for the travel agent? I don't know if we have any clarification.
Well, that's fine. We'll sign the letter. That's fine.
Perfect. All right, I appreciate
clarification on what that meant with the two, as I read them, competing clauses in there. We got clarification on that. No, if the baby can go, my guy will sign the letter.
Perfect.
Okay.
And I think the order will be, the order satisfies that too, but in abundance of caution, we're happy to sign the letter plus the order and should get the kid to the Bahamas.
Right. With the conflicting information, we just want to make sure all our bases are covered.
Okay.
So it sounds like we're all on the same page on that. That's good.
With that clarification, does the order seem to fit?
Yeah, that's fine. I guess we can, I think we're fine with that. Then we'll come back if we need to.
Well, I can either enter this order, or if you want, I can set a review out in a couple of weeks and see how you guys do.
Let's go ahead and enter the order, and then if we got to come back, Ms. Pinkerton or I we'll discuss that on Friday or after if we need to. Then we can bring in a motion to clarify or to tweak that somehow or set a specific schedule. But I think we got the gist of it, which is a good framework for that mediation. Now I think we got to just tie up the loose ends.
We'll keep our fingers crossed, and I've signed the order.
Very well. Thank you.
Thank you.
You're welcome.